When you're ready, come back into the space. Look at each other. Look at the beautiful people in this space. And I'm going to turn it over to Natalia.
All right.
Hi, good evening, everyone. Thank you for being here. I'm Natalia Serrano, and I am an organizer with the Justice Table. So the Justice Table is a criminal legal system change coalition that's based in Riverside County, and we're composed of organizations, nonprofits, and individuals who are focused on civil engagement, public safety, and increasing district attorney accountability. And thank you. So we are on social media as well. If you guys want to follow us on Instagram, it's on page 2 of the program. It's Riv Justice Table. Thank you.
And what would a candidate forum be without candidates? So we want to thank the 2 candidates. All 3 candidates were invited, just so you're aware. This event is hosted by 501c3s who are nonpartisan. All 3 candidates were invited out, and 2 of them have graced y'all and us with their presence, and we're just really, really grateful for y'all being here. Let's give it up for the candidates. Speaking of grounding and being grounded and all that stuff, we're going to have Luis Nalasto come up. He keeps us grounded, and he's going to ground us in some of the tech stuff.
Yay, tech. I think you can say those off. Either. Hey, everybody. Luis Nalasto, organizer with the ACLU SoCal, part of the Riverside Justice Table, and Food Tech. So I want to give a quick heads up. So we are joined by over 30 plus people from all over Riverside County on our Zoom. So we want to make sure to be inclusive of the folks that are joining us via Zoom. So we do have Spanish translation and ASL translation. So if there's community members that maybe want to listen to this, the recording and the live audio right now have those 2 accessibilities available. For when people are asking questions and the candidates are speaking, make sure to speak as close as you can to the mic, just so that the audio feed is available for the folks joining via Zoom. Lastly, but shortly, just a quick ground rules for tonight. So we're all here to learn. We're all here to hear from the candidates about their platform and their proposals if they were to be elected as Riverside County District Attorneys. So keep it civil. You know, if there's disruptive comment or disruptive activity, we will ask you to leave. We're all here to learn. Let's have some, share values. Let's treat each other as community. We're here to build community and learn, right? So let's just keep that, remind ourselves. Let's see, last but not least, restrooms to the right, down the hall. And then we have refreshments for you all. We have pizza, water. Feel free to help yourself. No food in the chambers. So if you do want to eat some pizza, we ask that you eat it on the hall or outside. And I think that's it on tech and ground rules. So with that, I'll pass it back to Bud.
Thank you, Luis. And without any further delays, I think we're going to hear from our candidates right now. So I think the first thing we should do is open it up for opening statements from the candidates. And I don't know if we decided who was going to go first. So I don't know, should we flip a coin? Should we pick one? Guess a number between 1 and 5? Who wants to? Yeah, we can do that. Anybody want to suggest a way that we can democratically decide who's going to go first? All right. Okay, I'm going to tell Toya a number between 1 and 10, and the one who picks the number closest to the number that I tell Toya goes first. All right. What number would you say?
4.
Number 4.
5.
Number 5. 6 is the number.
Hello. Not working.
Hit the button. Little button to turn down. Hold it.
yours.
I should know how to do this on the center, but here we go. Hello, my name is Lara Gressley. As the youngest child in my family, I was often accused of things I didn't do. This created problems for me and for my parents who had to work it all out, of course. And I think it was about 5 when I learned the word justice. I quickly figured out that justice means truth. It means that the wrongfully accused would be exonerated, of course, and that my sibling who actually committed the crime would be the one who was punished. Well, it didn't always work out that way. And maybe that explains why I've spent my career as an attorney fighting for justice. I've been an attorney for over 19 years. During that time, I have seen my fair share of injustice. I've watched the rampant overcharging of criminal offenses. I've seen innocent people convicted. And I have seen people languish in jail for far too long for no other reason than they were too poor to bail out. I've seen entire communities hurt by the criminal justice system, and I've watched prosecutorial misconduct go undeterred. As your DA, I will end the overcharging of criminal offenses. I will set the innocent free, and I will make strides towards reforming our cash bail system. I will end the racial bias that happens in prosecution, and I will never condone any unethical conduct by those in power. And tonight we're here for a DA candidate forum to answer your questions, at least 2 of us are. And I think that one of the most important questions that we have to ask ourselves is, what is justice? Because justice looks different in different cases sometimes. And so the one thing that remains the same is that justice means seeking the truth. It means just consequences for the guilty and setting the innocent free. Now, it's such a simple concept, isn't it? But it's absolutely been distorted. And I suspect that the reason that it's been distorted has something to do with politics, with money, and with power. But I am not motivated by those things. I assure you, I am motivated by God, by hope, and by an honest desire and commitment to make us all safer using a holistic approach to prosecution, which is the way that you obtain justice. In that effort, I will promote rehabilitation because I believe that everyone deserves a chance at redemption. And in the end, we're all safer when people are rehabilitated. I will tackle the jail overcrowding problem so that we stop wasting taxpayer dollars on needlessly lengthy pre-sentence incarcerations in our jails. And so we focus our resources on building up our communities instead of building more jails. And I will hold those in government accountable when they break our laws and our trust. Justice first, this is my promise. Thank you.
Okay, I don't know if I can go without a mic. I'm pretty good. But I wanted to say thank you. Thank you. Thank you for that, Lara Gressley. And we're going to turn it over to Burke Strunsky. And we'd like to hear your opening statement. That sounds like court, no? Not opening statement, your introductory statement.
Good evening. Okay, good evening. I'd first like to thank Justice Table as well as their partners for having us here, and Ms. Gressley for agreeing to this forum. So I am Burke Strunsky. I want to tell you a little story. On January 19th, when I stepped down from my judgeship, I took my 11-year-old daughter to Starbucks and I sat her down and told her that I was leaving my judgeship to run for district attorney. And as any 11-year-old would, she kind of cocked her head and said, "But Daddy, you're the judge." And she had that impression that so many people have, that the judge is the power player in the criminal justice system. But in fact, it's the district attorney. As was mentioned earlier, we learned that the district attorney decides when to charge a case, what charges to make, and when plea negotiations occur. That is where the true power in the criminal justice system. But what I tell you about why I'm running this, I'm running because I believe that the Riverside County criminal justice system is on a perilous course. I was a prosecutor for 15 years before I became a judge, and I've been a judge for the last 5 years. And I've had a front row seat to some really incredible injustices. So the difference between being a judge and being a prosecutor was a lot more substantial than I could have ever predicted. Being up there with a front row seat to justice without a dog in the fight really changed my perspective. I knew that as a prosecutor, I was always fair. But being fair is not the same as being impartial. And it allowed me to see the whole picture in a really profound way. And I can assure you that this election is about a choice. It's about a choice between the bluster of talking as a tough on crime prosecutor and actually being an effective on crime prosecutor. So time is limited tonight. I'd just like to talk about 5 things that I think effective looks like. First, we need to redirect resources to prosecutions that actually keep us safe rather than mindlessly racking up statistics. We need to recalibrate the filing unit. That means we have to stop being so aggressive on the front end and have so little discretion on the back end. I'll talk about that later on. We need to look at the way we file enhancements. They have to be filed for public safety reasons only. Right now, there's essentially a checklist that's used for filing. There is no checklist for justice. I'll create what I call a second look unit, a unit combining prosecutor-initiated sentencing cases and conviction integrity cases, a fully staffed, robust unit that's going to actually work to find these cases and fix past mistakes. And we're also going to put in the Racial Justice Act cases as soon as AB 256 passes, and those cases actually become retroactive. That's going to create a whole new type of case we're going to be looking at. I'll work on independence and transparency. As we know from the recent report that many in this room I'm sure are aware of, the district attorney's record keeping is just horrible when it comes to demographic statistics regarding filing and dispositions. We need to fix this. And I'm going to post those thousands of data points on the DA website each month so the public can evaluate our performance and see if there's any patterns of bias. I want to create a comprehensive juvenile diversion program. Right now, there is no juvenile diversion program here in Riverside County. We need to fix that. And I'll talk about that later on. Bottom line is Felix Frankfurter, Supreme Court Justice, once said that the law is a vital agency for human betterment. I could not agree more. That's why I got into criminal justice. That's why I became a prosecutor. That's why I became a judge. And that's now why I'm running for district attorney. I look forward to your questions. Thank you. Thank you.
Thank you. Thank you, Michael. And thank you. And speaking of questions, we have more water if you need it, but we're getting to the question part now.
Only one mic can be on, so the feedback we're getting is because of my sorry.
Thank you for telling us. Okay, so now we're going to get to the question part. The panel has some questions that they've answered during their introduction, but the Justice Table team has actually come up with some questions too, and they'd like to pose them to each of you. So who'd like to begin? Oh, okay. So speaking of justice, Justice is going to come and give us some questions. Thank you, Justice.
Hi, my name is Justice Sandoval. I'm a youth and community organizer with SBX Youth and Family Services. And, the DAs assert massive influence over how young people are treated in the criminal legal system. In Riverside, the DA is involved in multiple school-based programs, including STAR, School Threat Assessment and Response, and SAR, State Attendance Review Boards, allegedly aimed at supporting youth. However, these programs lead to early and increased exposure to the criminal justice system, tend to criminalize youth, particularly youth of color, and can result in life-altering outcomes for students and their families. So following that, my question is, should the DA's office be engaging with youth, and if so, how?
Okay, I'll start. So this is an important question. I was a juvenile judge for a year, and part of my my philosophy was we should do everything we can to make sure that youth do not come into the system. And one of those things that was mentioned was SAR, and obviously the district attorneys now are involved in the front end of the SAR process, from my understanding. We need to push that back. We need to only involve prosecutors and law enforcement in any juvenile matter as a last resort. And that is the philosophy that I think works best for the juvenile system. And that's why juvenile diversion, I believe, is so critical. The idea that we want to keep youth out of the justice system. We want to do everything we can to make sure they're not brought into the justice system. And that includes, and just to be clear, that includes any contact with law enforcement. We want to make these programs community-based. We want to get away from the law enforcement model of diversion and make the programs so that they involve community groups. Community groups are the experts in this field. Prosecutors don't have a lot of information about juvenile development, brain development, or any of the specific areas that these community groups are experts in. They're the ones that should be dealing with these matters. Law enforcement should only be brought in as a last resort, and that includes the district attorneys that are out there at the SAR meetings, and they're getting involved in the process way too early. We need to make sure that law enforcement is used only when all other measures fail to achieve the goal. And we all know that the YAP program was shut down after a lawsuit. It's no longer in effect, but we need a juvenile diversion program. And my hope is that we can restructure a real juvenile diversion program and scale off probation, scale off probation's involvement and limit it as much as possible, and actually use community groups to keep children out of the justice system. And I think that will go a long way to making sure that we have the kind of restorative justice that is so important, especially for our young people.
When it comes to youth, the primary objective, just like it is with adults, is prevention. So the DA's role, in the way that I envision it, is to prevent youth from going down a course that leads them to the criminal justice system. And what this looks like to me is actually some involvement by the DA's office, but not in a necessarily a typical law enforcement type of engagement. What I envision is engaging youth in education, internship opportunities, and retreats for youth where they can learn about the criminal justice system, where they can learn about the effects of crime on their community, on anyone who is affected by crime. And I talk about this a lot actually in my law firm because I have a young son who is 7 years old. And so it's constantly on my mind that I don't want him to be influenced or go down that path. So we have talked about this in my law firm about what we can do. And one of the things that we've come up with is take kids to court. Sounds kind of strange, but I think it would be impactful. If you've ever sat through a sentencing hearing and listened to victims speak about what happened to them when a crime was committed, it is impactful. And so one of my ideas is to engage youth in that process and let them come and see, really what happens in the criminal justice system and how it affects people. And then help them engage in their own communities and teach them how they can actually help their communities thrive and really, pay attention to what crime does to people, and so that it can be prevented. So that's just the engagement of youth question. It doesn't really get into the truancy part of it, the SAR part of it, which stands for State Attendance Review Boards. That I'm not sure if we're getting to that question next, so maybe I won't go there, but we really need to focus on prevention We need to focus on coordinating services for youth, and the DA has a lot of power. You know, when you call somebody and you say, hey, it's Deputy DA so-and-so, they're gonna listen and they're gonna say, oh, what can I do for you, right? Because it's a powerful position. So I wanna use that power in a positive way for our youth to try to locate services for families with at-risk youth and try to coordinate mentoring programs and mental health services and counseling. Right now, you know, youth is at risk for lots of reasons, not the least of which is the suicide rate from depression and bullying. I mean, when I was a kid, bullying was just in person. Now it's online too. You know, so we need to pay attention to this and make sure that we're reaching our youth in a meaningful way. And the DA's office certainly can have an impact on engaging the youth community and making sure that they have what they need and the knowledge that they need and the education and tools they need in order to thrive.
Thank you, both of you. So my next question is, while Riverside County has one of the highest rates of sending youth to adult court, so, you know, what do you think about that and how will you reduce those rates?
Yes, as we now know, Riverside County incarcerates youth at a rate of 2.5 times the state average and sends youth to adult court at a rate of 2.5 times, so a little more state average. So we're well above the average of the state, and we're being harsher on our children. And we use this word youth. I think sometimes it's too nice. It's too bland a term. We need to call them kids. They're kids, and we should call them kids because we certainly don't call. I don't call my 11-year-old daughter a youth, or I would call a 15-year-old a youth. I would call them a kid. And I think it's time we start realizing that these are children. These are kids. We need to take that. Well, Prop 57, by allowing judges to determine if a youth should go or a kid should go to adult court was a critical change because it allowed a fair process to determine in the first place if that child should be in adult court. And I think that was a major shift in the right direction. And we noticed that the district attorney's office here, even after Prop 57 had passed, tried to send youth to adult court, to keep them in adult court, even brought, you know, appeals to try to do that. And that was particularly troublesome because the law was clear and eventually the appellate court sorted it out. But the bottom line is allowing our children to stay in juvenile court, if at all possible, unless public safety mandates us sending to adult court, we will not do that. One of the things that I think is important to start talking about is the fact that we need to increase the age that juvenile court that it has jurisdiction over our young people, so that there's more time for rehabilitation, especially when the crime happens when the youth is 16, 17. And we need to expand the age. Right now, the age is 25 or 26. We need to expand that to 30 so that if there is a serious crime that's committed, the choices aren't just, hey, we can't do much for this child. We got to send that child to adult court for public safety reasons. Let's have at least the option to treat that child as a youth and give enough time for the rehabilitation to occur.
It's not a surprise that Riverside incarcerates youth at a higher rate. In fact, Riverside leads incarceration in many areas, over-incarceration, in my opinion. And really, when you're talking about kids, as Mr. Strunsky mentioned, you have to treat them as kids. And you have to avoid treating them like adults if possible. And obviously, as DA, you know, our number one priority has to be public safety. So it starts there. You look at the case, and it has to be an individualized assessment as to whether this youth needs to be treated as an adult for some reason. But I would imagine that would be absolutely the exception. and not the rule. Now it's been overused here, and Prop 57 did take care of a lot of that problem. So that's a good step in the right direction. But again, with youth being incarcerated, you have to look at the data and figure out what happens when somebody's incarcerated. What happens when a kid is incarcerated? And this is a traumatic experience. And so you have to be extremely cognizant of what you're doing when you place a child behind bars and what's going to happen in their lives, and you have to avoid it if you can, because honestly, this type of trauma doesn't lead to any good places. These children that go into jail essentially are going to be traumatized, and that's going to carry into their adult life. And it's going to cause problems later on, which means that we are going to have people reoffending later on. So, my approach to prosecution, as I mentioned in the opening part of this, is that it's holistic. And what that means is from start to finish, and then after they've served any time that they're serving, we have to be aware that all of this is a public safety issue. We can't wash our hands of something after someone pays their debt to society. If they need to go behind bars and they go behind bars because of public safety reasons, they get out, and it's still the DA's problem. One of the big issues I have with the way things have gone in Riverside County is there's sort of this washing of the hands after the sentence is handed down. Well, it's not my problem anymore. Well, guess what? It is your problem, because that person was incarcerated or has a felony conviction, and now they're going to come back into our community, and what's going to happen? If they are not rehabilitated, they're going to reoffend, re-victimize somebody. They can't get a job, they can't get a house, whatever the case may be. And when you're talking about youth putting them in that situation, that is extreme, because now you're essentially creating and you're putting into motion a course of events that's going to lead down that same path for the rest of their lives. So we need to avoid it. We need to be cognizant of it. We need to treat kids like kids. We need to make sure that public safety is #1 priority. But again, this whole thing is a public safety question. If we send somebody to jail or prison, that doesn't necessarily make any of us safer. And in fact, the evidence shows that a lot of times it doesn't. So that's my Thank you. Thank you.
Okay, my turn. Nope.
Hello. Okay, now to my turn. And just a quick reminder for presenters and for when we open it up to questions, just another reminder to speak slowly and clearly, just because some of our folks on Zoom are having a little hard time hearing us. So if you could just slow it down a little bit for our interpreters and a little bit louder. My next question. So Riverside County sentences people to death so frequently that it had become a national outlier. In 2015, Riverside County sentenced more people to death than every other state in the country, except for Florida and California itself. My first question, what are your thoughts on eliminating, I'm catching myself, 2 months. What are your thoughts on eliminating the use of the death penalty in California and Riverside County?
The death penalty. Okay, so I want to go over a little bit of data first about the death penalty. The National Science Academy report estimated 1 in every 25 people on death row are innocent. Let that sink in for a second. That means that if we execute the 747 people that we have on death row, we would be murdering 30 people, essentially. That's what that means. Let's talk about the fiscal costs, the fiscal problems with it. At its cheapest, it costs $1.1 million to prosecute a death penalty case. That's 20 times more than it costs to prosecute a life without parole use. And it costs California $150 million a year to house death row inmates. In 2017, Riverside County led the nation in the death penalty. And what that means is that there were more death sentences handed down in Riverside County than in any county in any state in the United States of America. There were 5 people that year that were put on death row. They were all people of color. And in 2019, we had 1 more death sentence handed down, and in 2020, we had 3 more. So we can't continue like this. Now, I understand that the voters, 51.1% of the voters voted to keep the death penalty in the recent election. And the way I voted in that doesn't matter because I'm not a policymaker. I'm not running for the legislature. I'm running for DA. And so I cannot give you a blanket policy because I don't believe in blanket policies. And the reason I don't believe in them is because I don't believe that I can circumvent the voters and the legislatures in what they say the law is. But I can tell you this. The death penalty should be avoided at all costs. It's absolutely untrustworthy. We have 5 people that have been exonerated from death row in California, at least 5 people since 1980. So how can you trust it? And when you look at the fiscal concerns, they're too much. It's too high a cost to our society, to our state, and to our county. We cannot continue this way. The governor has put a moratorium on the death penalty, and death row is being dismantled. It's expected to be dismantled within 2 years. So does it make sense? Not really. But what I can tell you is that I assure you that I will use my discretion reasonably, appropriately, and fairly, honestly, and with transparency in whether to consider the death penalty or not. But I believe that the facts and figures that I've given you, I'm wondering if the 6 million people that voted to keep the death penalty in that last election, I'm wondering if they would change their minds today hearing those things.
I've handled death penalty cases. I was a prosecutor in the homicide unit for 5 years. And part of being a district attorney is being a leader, and a leader decides how to allocate resources and what the priorities of the office would be. So this idea that somehow a district attorney shouldn't be the one deciding whether it's appropriate to see death penalty cases is contrary to the law, contrary to facts, and contrary to any description of what a leader does. And that's why district attorneys are elected to set priorities. So what I've said very clearly from the beginning is we are the state, we are the county that sends more people to death row than any other county in the nation. Often, as we heard today, 1 year we sent more people to death row than the state of Texas. So that gives you a sense of just how out of whack we are with the priorities of other counties. So what I've said very clearly is the death penalty costs $1 million more than a life without the possibility of case. That's just the trial. That's not even the appeals or any other process. That's a trial. So I've said very clearly, since we have not had an execution on a Riverside County conviction since 1961. Think about it, 60 years. JFK was in the White House the last time a Riverside County conviction resulted in an execution. So no matter what your ideology is about the death penalty, there has to be some common sense imposed here. We have to start saying, is that a good use of your taxpayer dollars, $1 million? Should we put those into testing rape kits? Should we put those into victim services? Should we put those into prosecution that actually make us safe? Leaders don't ignore reality. The reality is, and let me say this very clearly, there will not be an execution in this state in any time within anybody's in this room's lifetime. And so why would we spend $1 million each of these cases of your money? Why would we clog up the courts? And why would we continue to do something that where a recent study of Riverside County cases shows the racial bias that's been that is part of the decision-making process of the Riverside County District Attorney's Office. And one thing that study pointed out from the University of Florida was the fact that if the victim is white, it is three times more likely that the Riverside County District Attorney's Office would seek a death sentence than if the victim was a person of color. That alone should alarm us all about going forward and proceeding on these cases. We must stop this. We must impose a level of common sense, and we must use that money to actually do the things that a prosecutor is supposed to be doing, keeping people safe and getting justice for victims.
Second question, what will your policy be to revisit death sentences, and what would be the standards you use?
So I want to talk about how I look at all cases where we're reevaluating sentences. And I don't know if we're going to talk about prosecutor-initiated sentences, but it's part of that same conversation, because what we know is, one, those cases are well out of the appeals process, going through the appeals process. They're no longer cases that the Riverside County District Attorney's Office is handling. So we can use the same logic that we have prosecutor-initiated sentencing cases. Is there some extreme injustice that needs to be rectified? And we'll look at all these cases. We'll look at cases that scream out for justice and reevaluation. If there's an issue where we felt, and one of the things I've talked about at the beginning of today was the fact that we're going to have likely this new retroactivity of the racial act, and we're going to be able to actually go back and see how race played a role in the conviction, the prosecution, or the decisions in these cases. And once we do that, we're going to be evaluating a lot of these cases. And that's one of the reasons why I want to bring those cases back and put them into a unit of prosecutor-initiated resentencing cases and conviction integrity cases to figure out if there was any kind of racial bias that led to this conviction. And I think it's the Racial Justice Act. I'm not sure I said it properly, but that's, if current legislation passes, that act will become retroactive, and we're going to start evaluating cases where people are currently serving prison sentences in situations where there was some allegation of racial bias in the process.
So just like any wrongful conviction, which could be an innocent person, it could be someone who was over sentenced, it could be somewhere along the line there was prosecutorial misconduct, or there was false testimony, or there was ineffective assistance of counsel. So we have to look especially at death penalty convictions, because obviously those are fatal sentences. And so we need to make sure that the trial phase was trustworthy, the penalty phase was trustworthy. It's going to take some time to go through those. Those are very large records. But fortunately, we do have the ability to do that in the DA's office, because I'm not sure if we'll be talking about this, but I will have a wrongful convictions unit. That unit will be established to look at cases and prioritize from the most lengthy of sentences, and obviously death penalty cases would be part of that analysis. And as well as the prosecution initiated resentencing, which is a pilot program right now. I don't know if we're going to talk about that, so I'll mention it real quickly. $18 million in California has been allotted to 9 counties in Riverside County made the list. So we're going to have money for that. That's a really important thing, because we have a lot of new laws that recognize that our sentences are extremely harsh. And you know, one thing that I want to touch on is that there's this misconception, I believe, in some communities where they believe that, you know, people are getting out without, you know, harsh penalties. People are getting off easy, that sort of thing. And I can tell you, I've been doing this a long time. It's a misconception. These sentences in California in particular, I mean, the penal code over the years just gets thicker and thicker and thicker, and the print gets smaller and smaller and smaller. And the reason is because there's more laws, they're harsher, there's more, sentences, and that's why we rolled back, and the voters have voted on that, and the legislature has enacted laws, and there's been referendums. There's a reason for that, because it makes sense to do that. We're looking now at all these studies that are coming out where it's showing that this is not making us safer. And isn't that the point of our criminal justice system? Not just to punish, right? But to make us safe. And so we need to pay attention to the data, because that's the truth, right? And we're always going to be seeking the truth. That is the point of justice. So again, we look at this data and we see how it doesn't make sense to have these extremely harsh sentences. So again, with the death penalty, we have to take a hard look at these cases. And unfortunately, the incumbent has given us a lot of cases to look at, because we are in bad shape when it comes to death penalty. In 2020, there was a Desert Sun article that came out, and I found the data on this. I didn't before, but I did find it on the Death Penalty Information Center website. 16 death sentences were handed down since 2015, it said. So it gave you a 5-year span, 2015 to 2020, and it records 16. I mean, it's at the top of the list. So this is going to be a lot of work, but we're going to have to use the resources we can, because we have to make things right.
So we had another question from another presenter that's on the Zoom, and we didn't really think it through about whether we're going to ask a question. So I'm going to ask on their behalf. So this is on behalf of Alan Edwards, who is a policy fellow with Starting Over Inc. So this is the question and the topic that they had, which is fines and fees. The first, so the involvement in the criminal legal system often drives low-income people further into poverty. So the two questions on this issue are: one, as we speak, thousands of individuals are sitting in Riverside County jails, separated from their families, solely because they are unable to post or pay bond. Do you believe that we should abolish cash bail in California?
Sure. Yes, the answer is yes, with a caveat. We need to prepare for it. So first of all, I think people misunderstand what it means to get rid of cash bail. Getting rid of cash bail does not mean that nobody's going to be held pre-trial. It does not mean it. It means that we're no longer going to tie freedom to money. That's all it means. And it's going to. And when you think about it, if you have a system that says, we're going to decide whether you get freedom based on the amount of money you can post, is there really any way to make that an equitable system? It's impossible. It's always going to favor somebody who has more money. So we need to scale off cash bail, but we need to do it carefully for public safety reasons. So we need to create a robust pretrial service unit, a unit that actually has things like paid for GPS services, drug treatment, other kind of services that are needed to protect the public and make sure that the charged person gets back to court. But to your question, there's no way to make cash bail a fair and equitable system, period. It is always going to favor somebody that has more money. And that's a textbook definition of a system that is not fair, just, and treating people equal. And that's a fundamental part of our justice system, treating people equal. And that's why people are not happy about the idea that we have cash bail, because inevitably you're going to treat people differently based on the amount of money they have in their bank account. But we need to be really careful here and create a robust pretrial services unit so that we can make sure that the people that we do release pretrial have services and can be monitored outside of custody, so that we can in fact ensure public safety and keep the people that are a public safety threat and a true public safety threat in custody and make sure that that is not determined by the amount of money they have in their bank account.
We definitely need to reform our cash bail system. If somebody who goes to jail because they committed a crime and they don't have any money, and somebody else goes to jail because they committed the same crime, allegedly, and they have money and they get out. How is this fair? This is not fair. This is not what we are about in this country. So we need to reform it. So what's the answer? Well, the answer is we need to start looking for ways so that judges will feel safe in letting people out. See, this is the problem. We already have a California Supreme Court case called In re Humphrey. They came down and it said, hey, you need to inquire as to whether the defendant is able to afford the bail, because that's the question, right? And if they can't afford it, then you have to find the least restrictive alternatives to keep the community safe. What happens in all practicality, and I can tell you because we've had lots of these cases in our office, and we've talked about the issues, is that when a defendant wants to go and challenge the affordability of the bail, the judge says, well, I have to tell you, if you make that challenge, then I'm just going to preventively detain them because we don't have anything that will ensure me that the community will be safe. So the fear about whether the community is safe is real and it needs to be addressed. And again, running for DA, public safety, top priority, right? So the DA has to feel safe that the community is safe in making that decision. But again, the DA only has a recommendation. The judge makes the determination. So we have to make sure that we are seeing that this is a real fear that the judges have. They don't want to be the one who lets somebody out who then the next day they're in the newspaper and it says that, yeah, this person killed somebody or hurt somebody. So I'm telling you what, we have to come up with real solutions that involve monitoring programs, house arrest, you know, all the things that Mr. Strunsky just talked about. We have to find those, and then we have to apply those in cases where people cannot afford bail. Because if we don't do that, we're going to continue incarcerating people because they're poor, essentially. And right now in our jails in Riverside County, roughly 80% of the people who are in our jails right now are awaiting trial or resolution of their case, 80%. And you want to talk about fiscal concerns, we can do that too, because it costs $60,000 to house one person in our county jails for 1 year. So, you know, if people hear these numbers, they're going to take a big step back and go, wait a minute, we need to fix this. And, you know, there's all kinds of reasons to fix this, right? It's not just the mere fact that it is absolutely unfair to incarcerate someone because they're poor, essentially. But we need to find these solutions. They're out there. We can work with community organizations. We can find places that will monitor residential rehab. You know, maybe it's a drug case and a case involving alcohol, substance abuse, mental health. There are places that will provide those services and will monitor people. It's just a matter of finding them. And we haven't been looking because the right person has not been in office. And that's really the answer. And that's why we're here tonight.
Good evening. We got me having two subject matters. I'll start with ending over criminalization and mass incarceration. Riverside County has an incarceration problem. Riverside County historically has relied on cases to fix systematic social problems rather than addressing their root cause. The county chooses to prosecute crimes of poverty and mental illness rather than provide the services and programs that community members need. The county continues to raise the budget allocation for incarceration by policing while it cuts important social safety nets programs and resources designed to improve mental health, housing, and education. First question would be, Many community members have noted that prosecution from Riverside County District Attorney's Office is often excessive and overzealous. What are your plans to address our county's current desire to seek the maximum amount of time possible at the time of sentencing?
Well, I definitely talked about this already. You know, it's part of my platform. It's one of my major issues in my platform, which is to end the overcharging of criminal offenses. Now, this happens to be near and dear to me because I have worked as a criminal defense attorney, and I have seen cases that are so overcharged you wouldn't even believe it. People walk in my office and tell me, well, I got arrested for this, but they tell me what happened, the circumstances of it, and they say, well, they're not going to charge you with that. And then I go to my computer and I look it up and I find that they did. And then there's the sort of shock that I shouldn't have anymore after this long working in our criminal justice system here in Riverside County. But it's still shocking because I just can't believe it sometimes. And in one of those cases, it was a very good person who was a good Samaritan and actually intervened in a scuffle and ended up getting charged with a strike offense and another felony. Ended up the risk of losing his professional license. He was a Canadian citizen, so he would have been deported. And the pressure that I felt in that case, I can't even tell you. And this person is a good person. But what happened in that case was that it was overcharged so much that the bail was extremely high. So he had to pay bail. And then he had to hire an attorney to represent him. And then he had to go to court with the shame of facing these charges every time. And what happened in his case was a success story. It wasn't as successful as it should have been because a dismissal would have been more successful. But we ended up 9 months later with a very low-level misdemeanor, disturbing the peace, and no probation. Terminal disposition is called. So I am not a miracle worker, okay? I am not a miracle worker. The reason that I ended up with that at the end, the reason that he ended up pleading guilty to that was because it was extremely overcharged in the beginning. That's one example. I have many. So I know for a fact that this happens in this county. I have spoken with defense attorneys across California who won't even step foot in Riverside County because they don't want to deal with it. It's too hard. I have been asked over the years, why don't you go work somewhere else? You know, why do you stay in Riverside County? And you know, my answer ended up being because I care about the people here. And I care about justice. And I love the law. And I love what I do. And so I stayed here all these years. And now I'm up here for that reason. Because I'm fighting for justice for every single person. And overcharging people doesn't make us safer. It makes us less safe. And it makes incarceration rates go up. And it makes our jails overcrowded with the 80% of people that are in there now because they can't afford bail. You know, so we have to look for other solutions, and overcharging will end the moment that I step foot in the office.
So harsh sentencing starts in one place, and that's in the filing unit. And so I'd like to talk about that. I addressed it briefly when I started talking to you this evening, but the real problem is not what happens in court at the day of sentencing. The real problem is what happens when the case is brought by the police to the district attorney's office for filing. And right now, what we have is we have an overly aggressive filing practice and an overly restrictive disposition and discretion policy. And so what that creates is on the front end, when you have these very preliminary facts. Often the facts are incomplete. Sometimes they're wrong. But the filing decision is made at that front end. And then there's often by a mid-level deputy district attorney. And then the case essentially gets this inertia going through the system where you have this very serious charge. And even as evidence starts coming out that shows that the charge isn't as strong, or the criminal history isn't as strong, or it's really not that bad of an offense as it looked like initially, the district attorney holds very firm to that charge and the way it's charged and the enhancements and all of those things that form the bulk of this very coercive potential sentence. And what that often results in is a defendant taking a plea, and often on the recommendation of their attorney, and often it's a good recommendation because the alternative is so extreme. But sometimes they do take a plea to something that they may not have done, or it may have had happened differently than the conviction seems to indicate. And the point is, when you charge somebody in this extreme way, like we often do in Riverside County, you're creating a coercive and unfair plea bargain process. So the goal should be to create flexibility and fairness through the entire process. Yes, decisions that are made preliminarily should be looked at as preliminary decisions. They shouldn't be looked at as decisions that necessarily should control the process all the way through. And I think that creating some fairness and flexibility through the process is really going to help us make sure that we send, we charge cases appropriately, and we get the best dispositions by creating a little more flexibility and fairness. I also want to talk briefly about mental health and drug treatment, which is not being used effectively currently in Riverside County. We need to start understanding that these are not just alternative sentences. These are actually really good public safety measures. And I think part of the problem with the way they're being received is there are suggestions that these are alternatives or soft on crime kind of routes. And I can tell you, as somebody who's done drug court, I can tell you this holistic approach really works, and it works a lot better than sending somebody to prison for a few years. If we can get them into this comprehensive 18 months drug treatment, job training, behavioral health treatment, all of these things come together and they go to court every few weeks in front of a judge who reinforces these things. I'm telling you, these people that have been in the criminal justice system for 10, 15, 20 years suddenly find that there is a life outside of criminal justice because somebody believes in them. For the first time often in their life, they have an authority figure, a judge or a prosecutor who comments on what a great job they're doing and pushes the fact that if they can make it through it, they can get through that treatment program, if they can, get a job. And these people walked out of my courtroom. I cleaned their criminal records completely. I expunged everything I could. They walked out without a criminal history. It was on them at that point. But they were given the opportunity, and to my knowledge, they've all succeeded. They were employed, they were paying taxes, they were paying their child support if they needed to, and they were doing the things that we want our citizens to be doing. The success is extraordinary, and it's being underused here in Riverside County.
All right. I was told I was only able to do one more question. My question is going to be on mental health. I'm going to do this from the cup. I know Riverside County has a mental health court. I was privileged to sit in a couple of cases where the individuals had mental health history, but due to the nature of their crime, they were the DA had an unwillingness to allow them to even be considered for mental health court. What would be your standings on that?
So there's mental health court and mental health diversion. I point out the difference really quick because I think it's important to answer that question. So mental health court is not a diversion because they plead guilty. Eventually they'll have their convictions expunged if they succeed. But with mental health court, the MOU created by the district attorney allows them to have essentially a veto. So the district attorney is the only party in what is called a collaborative court that actually has a veto. Even a judge couldn't allow a person into mental health court that the district attorney objects to. So there's not a lot of collaboration there. We need to at least evaluate people for these courts if they are statutorily eligible. And what I often did is I referred over the DA's objection when I was sitting in a criminal court, and often those people would come back, the DA would in fact veto. But once that conversation started, that collaborative conversation of behavioral health, probation, and the defense and the prosecutor, all of a sudden everybody realized that this is really a good candidate. But based on the charge alone, they were vetoing it. So one, let's get people evaluated, and I think we can start a conversation that may in fact mean that the district attorney is not going to object. And the second is mental health diversion, which a judge can send over the district attorney's objection. And I can tell you, I did this on a regular basis in my calendar court because the district attorney looked at the case, and if it was a crime of violence, they almost always object. And even if everybody was in agreement that the core problem that led that person into the criminal justice system was in fact that mental illness. And we know that 80% of people that are booked in the county jail have a mental illness, a drug problem, or both. And so if we don't start looking at mental illness as a good public safety solution, and not just an alternative, not just the right thing to do, although it is, but actually as a good public safety measure, one that keeps us safe. Because if we don't start treating mental health and we just continue to send people to prison, they're going to come out, as we all know, worse, and public safety is going to be compromised. So let's do it right. Let's start really being smart about the cases that we send to mental health court, mental health diversion. Let's scale up those programs so that we can actually start cooperating with other programs like the Governor's Care Court and actually figure out a way to make sure that we actually have the mental health services. Because that's one of the problems, because there hasn't been a dedication to that here. We're going to have to do a lot of scaling up of these programs. There are a lot of drug treatment programs. Mental health is going to be something that we're going to have to work very hard and form collaborations and partnerships to make sure that we have the infrastructure to start scaling of mental health courts and diversions. And that's something that I look forward to.
The MOU, or the Memorandum of Understanding that Mr. Strunsky was talking about, is a perfect example of just how much power the DA has. So they have veto power based on this MOU. That means they can just say, nope, sorry, don't want to do it. So that's a perfect example of that. And then we just were talking about overcharging. And they have the power to decide what the charges are. So they decide what the charges are. And we know that people have been overcharged a lot. And then they decide, nope, not good for that charge. We need to start looking at the root of the problem. Because if we don't deal with the root, then it's just going to keep happening over and over and over. And with mental health court, yes, there's this veto power, which I don't particularly agree with, because normally a veto power would be a separation of powers violation, right? Because you have the judiciary branch, the executive branch, and the legislative. But with this, it's definitely a memorandum of understanding that gives them that power. So that may not work out so well. We need to change the way things are done. Now, obviously, the mental health diversion court, or mental disorder diversion, is an option that is statutorily available for certain individuals. Again, the problem is that some crimes are accepted from that. And so we need to, number one, be cognizant of what we're charging people with. Is this really what they did? Is this really what we should charge them with? Because the answer, or the question, has to begin with, what should we charge a person with, not what can we charge them with? You know, we might be able to charge them with 5 different crimes, but maybe they should only be charged with 1. So these are, it has to start in the very beginning, again, this holistic approach that we've been talking about. And, you know, I have personally witnessed people being turned away from mental disorder diversion. I have an autistic client that was turned away from this and who would absolutely benefit, would absolutely be rehabilitated completely. and would absolutely serve the purposes of justice in this particular case, but it doesn't always happen that way. So again, you know, I think that it's always an individualized assessment in every case, how we deal with mental health issues, and we do need more services. So we have to find the programs that are working and duplicate them. You know, we have to focus on community organization support, and sort of my vision includes kind of what I see in my mind is a big, huge round table, you know, in that big, huge office that is the DA's office. And I want to invite people to sit at the table with me. And it's not just the department heads, but people on the front lines who are out there, you know, interacting with people with mental health issues, interacting with people with substance abuse issues, and figuring out what the problems are. And everybody can bring something to the table. They bring a problem and I want a solution too. And then I want to know what their thoughts are and how I as DA can impact that. So I think that the answers are out there. The organizations are out there. The people are out there. That I mean, there's so many intelligent people in our county, in our community. Let's get together. Let's talk about these problems. Let's figure out why, you know, somebody's being 5150'd, and then the running joke is that they make it back to where they were picked up before the law enforcement officer does. You know, this is what the joke is. Why is that happening? You know, they just ask them a series of questions and send them on their way. And then we have this revolving door that just keeps going on and on. So, you know, their answers, we'll find them. I will search hard for them from the very start of my public service job.
So I will be asking a question on police violence. At least as most of us might know, that there's too many law enforcement officers that disobey the law and hurt or kill people with impunity. In 2017, officers killed 172 people in California, only half of whom had guns. In Riverside County in 2021, it was the deadliest year on record for officer-involved shootings, with a total of 14 fatal shootings involving Riverside County Sheriff deputies. So that being said, under California law AB 392, the state narrowed the circumstances when police officers are legally allowed to use deadly force. What would you do to ensure the district attorney's office accurately applies the changed law and does not rely on the previous legal standard in deciding whether to charge police officers who kill?
Okay, this is so first of all, AB 392, just for everybody's information, it essentially created a more objective standard for police officers' conduct. It really added the word reasonably objective and created a totality of the circumstances. So we're looking at everything and we're looking at it as a reasonably, from a reasonable objective standard. Frankly, it just puts, it's the same standard that we apply in the law for everyone else. And so, but we can change the standards all we want. But if we have a district attorney who is principally funded by the police unions, by the sheriff's unions, that district attorney has mandated criminal oversight over law enforcement. So think about it this way. The district attorney is actually the chief law enforcement officer of the county. District attorney is a civilian oversight over the police department. And one of the things that has been allowed to happen, there's legislation, hopefully that will pass in Sacramento that will prevent this, is the district attorney is also principally funded. What gets this district attorney elected to office is money from police unions. The majority of the money is received for his campaign has come from cash from police unions. Just to put this in perspective, these unions, and I want to be clear, I've worked with officers as a prosecutor for 15 years. Some of my friends are police officers. I have great admiration for them in general. But the police unions will be actually funding the defense of these officers if Mike Hestrin decides to charge him. Just think how stark and troubling that conflict of interest is. It wouldn't be allowed in any other legal environment. Somehow we allow the district attorney to be principally funded by the same organization that will ultimately provide the defense of the person that he's investigating. That doesn't exist anywhere else that I know of in the law, but is allowed to happen here. And the problem is, whether Mike Hestrin makes the right or wrong call of these officers involved in misconduct cases, his decision will always have the appearance of being final. And that's something that will destroy the confidence of the community in law enforcement. We need to get that back. We need to know that there is a separation of powers between police and prosecutors, and that is fundamental to the integrity of the entire criminal justice system. Prosecutors and the police work together, and there's got to be some very strong collaboration, but there also has to be a separation between the two, and they cannot be dependent on the same source in order of cash to get reelected every year. And that's why we saw the Attorney General step in already to prosecute a case that Mr. Hestrin refused to prosecute. We need to start looking at the way these cases are analyzed. We need to start asking ourselves, why are these grand juries being used? Why are these grand juries that are used so infrequently in cases in California criminal law? Why are they being used for officer-involved misconduct? Why are those confidentiality procedures being used when officers are involved, but not when other people are involved? And why aren't we disclosing that information to the public so that we can actually see for ourselves what happened in those proceedings, to make sure that what evidence was presented, and to see how the evidence was presented. Let's start looking at these cases and say, we need to have a level of transparency here, especially when an officer, member of the government, ends the life of an unarmed member of our community. We have to know what happened. And when we have this level of bias, this level of dependence of our chief law enforcement officer on the sheriff's department and on the sheriff's union to get reelected, we need to start asking a lot more questions.
Well, I'm gonna come out and say it. What happened in the Corona Costco shooting case? Why was Salvador Sanchez, the officer who killed Kenneth French and seriously injured his parents in a crowded Costco 22 feet away, why wasn't he charged? Well, we don't know. And you know why we don't know? Because the incumbent convened a grand jury, and that grand jury did not come back with an indictment. And what happens in a grand jury when there's what's called a no bill is that it's sealed, completely sealed. So we can't see what happened. There's no transparency. And how can we trust it? This is my question. You know what we do know, though, is something called circumstantial evidence, which is that after that grand jury did not indict that officer, is that he was fired by LAPD because they found it unjustified. And we also know that there was a wrongful death suit in a federal court, and a jury awarded $17 million to Kenneth French's family. And we also know, as Mr. Strunsky just mentioned, the Attorney General, Rob Bonta, intervened and charged voluntary manslaughter and assault with a firearm. At a recent debate, I brought this up when we were asked about how we would deal with accusations against police officers. Now, the first thing that I said was, when they asked, well, how are you going to handle those cases? And I said, just like I handle every other case. And I got some resistance from the audience because they were shaking their heads, and I'm going, why are the people from the DA's office shaking their heads right now? Because here's the thing, either a crime was committed or it wasn't. That's the question. Why are we treating it so differently? It's the same question. Now, the analysis is different because we have PC 196 and 835 that were amended by the Assembly bill. So we know that deadly force can be used under certain limited circumstances, and that has to be taken into account. But it's just like any other case. Was there a crime committed? If so, what was the crime, and how do you charge it? But instead, Mike Hestrin chose to convene a grand jury in that case. What did he ask for? We don't know. What did he ask for? And at a recent debate on March 16th, you can go back and watch the video because I believe that he sort of indicated what he asked for. And so I encourage you to go back and look at that footage and see what he said. The other thing that happened that was interesting was I brought up the law enforcement money because there's a whole lot of it, as Mr. Strunsky just mentioned. And just before the new law came into effect that capped contributions to $4,700 in California, and then the Board of Supervisors changed it here to $20,000. What happened was just a few days before that, Mike Hestrin got about $210,000 from law enforcement tax. And I saw that and said, well, isn't that nice? So, you know, now we're in a race where we're capped and he already got that money. And I'm asking the question, what does that buy? What does that buy? You know, and it really is the appearance, if nothing more, it's the appearance of a conflict of interest and needs to be absolutely avoided. I don't think it's appropriate. This came up when I ran the last time in 2018. And they said, you wouldn't take the money? And I said, no, because then, you know, I'm in a position where I appear to the public whom I serve as though I am making biased choices. So it's not the fact that law enforcement officers donate it, it's the fact that these unions don't donate these huge amounts of money. And we know, as the common interpretation is, that money gets votes. And you know, that's pretty much what's been happening. I wrote an op-ed on it a few weeks ago. It was in the Press Enterprise. If you want to go read it, it's there for you. And I talk about the Costco case. And I think that we need to prosecute law enforcement who break the law just like we would prosecute anybody else. They're not above the law. Nobody's above the law. And we have to make sure they're held accountable when they break the law. But having said that, I can tell you, I support law enforcement. I'm running for a law enforcement position. So I support law enforcement. I want to help them do the job. I want to train them. I want to educate them on constitutional law, which I happen to be an expert in. So I want to use those skills to help our law enforcement officers do their job well, so they can serve us and protect us, because they are absolutely critical in our society to making sure that we're safe. So I'm going to work well with them, and I have no problems with them. In fact, I have lots of friends who are law enforcement officers too. So, you know, and people make mistakes in any profession, and but when they break the law, there have to be just consequences. We cannot just not charge it.
Okay. Hello, Jessica. Good evening, everyone. Thank you, candidates. My name is Toya Vick, and I am a member of the Justice Table. I'm a participatory defense organizer, criminal, and housing justice advocate, and so much. So tonight, my topic is housing and homelessness. The context: providing people with safe, affordable housing is widely acknowledged as the most effective, humane, and fiscal responsible way to end homelessness. But the progress is too slow, primarily because policymakers have failed to commit to the resources needed to end the crisis. The limited time, I only can ask you one question. So, will your office decline to prosecute crimes of poverty? For example, there are hundreds of laws that criminalize poverty, such as bans on sleeping, sitting in public, camping in public, loitering, panhandling, and etc.
So a couple of things here. First, in 2018, I think in this very room, actually, Mike Hestrin said that he had created a juvenile diversion program, excuse me, a homeless diversion program. And now he has a new homeless diversion program that is proposed now that we're back in the election cycle in 2022. So let me tell you a little bit about the program because it's somewhat disturbing. So he said very clearly that his program is based on putting aside enough jail space. So again, we can't even keep the felons in jail, and he wants to put aside some jail space for quote them to, I believe he said, dry out and bring in people that are charged with these minor crimes that we've listed. And have them dry out. So in other words, he's saying have them detox in custody. And as everybody in this room likely knows, that is not only cruel, but incredibly ineffective. And the idea that we're going to have somebody go through detox in a non-therapeutic environment, and there's nothing less therapeutic than a jail cell, is cruel and has the added problem of being just completely ineffective. And that is the solution that too often we come to with trying to solve the problem of individuals experiencing homelessness, which is we look to the criminal justice system for a solution. The solution is not in the criminal justice system, period. It never will be, it never has been. We make the problems worse here in the criminal justice system, not better. We often take people into custody with homes and release them without homes. And we have to start realizing that we're actually causing more homelessness than we're remedying. So one thing we got to start doing is diverting these cases into this new program. And there's not a lot of details on it, but it's a statewide program called Care For It, which is essentially going to change these cases over to this. It's going to give us the option of putting these cases in civil court and using certain measures like conservatorships to make sure that people get the services they need. And we're not treating people that are merely individuals experiencing homelessness as criminals. We got to stop doing that. We're making it worse, and it's cruel, it's inhumane. It's not who we are as a country. And it's time that we start saying the criminal justice system is not going to be responsible for prosecuting crimes against a group of people merely because they live in poverty. That is unacceptable, that is un-American, and we're going to stop it here in Riverside.
So when it comes to homeless and homeless crime, I propose a homeless crime task force. And what this would look like is it would be public agencies along with private service providers getting together with me and my office and resources that we have. And what I want to do is prevention and intervention. And I think that, this gets back to this vision that I have in speaking with the community and the people on the front lines that are interacting with the homeless to find out why they're there, what can be done, and essentially, are they open to services? In my opinion, since I actually know some people who head up homeless projects and foundations, I have had personal conversations with these individuals and also the people who run these programs. And I can tell you that Mike Hestrin disagrees with me on this, but I can tell you there are a lot of homeless that are open to services, that actually want the services. And so we need to find them. And then we need to get them coordinated and set up with the right people in the right place. So that's an important part of this. But again, we have to understand the issues, the mental health issues, the substance abuse issues that are happening And it all goes back to what I talked about in the beginning, is building up our community instead of building more jails. You know, the last time I ran for office in 2018, I talked about a jail that at the time was $333 million, but it's actually like about 400 million that we spent on the jail out in Indio, and it's not at full capacity anyway. So, you know, it looks like that building being erected was not, as it turns out, the best solution to our jail overcrowding problem. And I also had the same reaction when I read the article about the homeless, you know, being in the jail and having beds set aside. And I think Mike Hestrin's words were, I hope the sheriff sets aside beds. And I'm going, well, where's he going to find these beds? You know, I don't really understand, because we have such a jail overcrowding problem as it is. You know, and that's not even getting into the detox issues and all of that. So again, I think we need to focus on our community. We need to reach the right people. We need to duplicate programs that are working. We need to sit at that table and talk about the problems and find solutions. We absolutely can do this, but no DA, since I have been aware, has ever led such a conversation. So that is my plan. And right now, just to give you an idea, well, this is 2020, so it could be a lot worse, but that was the last count that I found, was 2,884 homeless in Riverside County, and only 729 of them were sheltered. So this is a big problem. And, you know, then we have the loitering that happens, and we have trespass, and we have various, you know, petty crimes that are happening. So let's deal with the issues so that we don't have this revolving door. And then we can take advantage of the new collaborative courts or the care, you know, programs, and try to figure it out as well. So I'm a big proponent. As I said, rehabilitation over punishment is what I look for, because that's going to help public safety, which again is the #1 priority as the DA. So looking at it from a holistic perspective, you can see how all these pieces work together. And if we are helping the homeless be unhomeless, and we're preventing crime and intervening and getting services, then we are not being social workers. As some people said, well, the DA is not a social worker. Well, guess what? It's called prevention. And prevention is absolutely within the DA's purview, and it's 100% what we should be doing, because it is a public safety issue when you have recidivism, repeat offenses. Let's get to the root of the problem and fix it.
Thank you.
Now it's time for the audience questions, and so we're in a little bit of a pickle. We're a little bit over time, but if it's okay with you both, maybe we can just make the answers to these questions a little bit shorter, just so that we can maybe get to a little bit more of these questions. So the first one, and this is just like I'm trying to merge questions based on things too, because a lot of them are very similar. So this first one, I think, is an interesting one. It's talking about culture change if elected DA. So how would you go about addressing budget management and fiscal waste amidst sort of the current recession? And what would you do to sort of create change and work with other existing agencies like law enforcement to make real systemic change?
So I'm going to take this opportunity to talk about the budget, because one of the things that people are just starting to realize is, just since Mike Hestrin was elected, the budget increased in his office by 53%, just since he was elected. So it went from about 104 million to about 161 million, just in the period of time that he has been in office. And yet, if we look at the Judicial Council statistics, they show us that, in fact, he's filing less cases, he's taking less cases to trial, and we're learning that the dispositions, the verdicts in those trials are exceedingly bad for in the recent past. And we also know that he's disposing less cases. So we know there's 1,800 cases currently set for trial, with 12 or 13 trial courtrooms here in the county. And the reason is the Supreme Court of California gave the District Attorney's Office 2 years to help to deal with the backlog from COVID. And yet there's been no attempt to settle low-level and mid-level cases. So we're headed for a public safety crisis being layered on a public safety crisis that we're already experiencing with the uptick in crime. And now we have 1,800 cases, 12 or 13 courtrooms. That's about 150 cases for every courtroom. And so this is an extreme public safety threat. And the reason we're here is the inability to resolve low and mid-level cases in this county, so that those courtrooms could be used for the rapes, the robberies, the murders, the cases that need those courtrooms to protect public safety. Instead, we have 1,800 cases. We're getting to the end of the extensions, and we're headed. We have essentially a tsunami coming as far as cases set for trial. And I just wanted to get that in because I think it's important that everybody here realize that.
The budget. Well, the first thing I'm going to do is take a pay cut, because in 2018, Mike Hestrin got elected and we got a raise shortly after. And I'm suspecting that everybody just underneath him got a raise too. So I'm going to take a pay cut because I'm a public servant as DA. I'm not serving myself, serving you. And I'm also going to find people to put around me that will also take a pay cut. You'd be surprised how generous people can be when it comes to a calling, when it comes to something that really matters. And so that's my first order of business. And then we're going to look at everything else. And I'm going to engage a consultant for that, because I don't pretend to have all the answers. But fortunately, I know where to look to find those answers. And so I'm going to bring an expert in, and we're going to find answers to cut our budget. And then we're going to streamline things. We're going to improve the case management system, which I'm told right now essentially doesn't work. So we can't even track data. You know, we're going to do stuff to make sure that we're using the money that we have and we're putting it in the right places. And, you know, we're going to do stuff like prevent lawsuits, sexual harassment lawsuits that have been happening in the DA's office that are settling and costing taxpayer money. And then the training that I'm going to do with law enforcement is going to prevent police violence, which is causing lawsuits and huge settlements that comes out of your pockets and mine as citizens of this county and taxpayers. So there's a lot of places that we need to save money in Riverside County. Again, I talked about the taxpayers saving money with, you know, essentially ending the mass incarceration we have in our jails. But in the DA's office, there are a lot of places that we can improve on. And the first order of business is I'm going to take a pay cut.
Thank you. So I have a question through Zoom. Riverside County is saturated with low-wage jobs, and many times these employers break the law with wage theft. Will you actively investigate and prosecute for wage theft?
Yes, and in fact, this is something we've spoken up quite a bit about. When the idea that, and I mean, this often hurts, obviously, very low income people, communities of color, where there are attempts by employers to use coercive methods to keep employees working more hours and not paying them appropriately for different jobs they're doing. That's unacceptable. We need an economy that treats everyone equal. This is not just a minor issue. This is a big part of what I've campaigned on. Because I think it's critical to make sure that when employers, it's critical that employers know that it is unacceptable to attempt to use coercive methods to get their workers to work more hours or to work different types of jobs. That's theft, just like any other theft, and it will be treated as such by this district attorney's office.
I agree with Mr. Strunsky. And I think that especially in these times when we have joblessness happening, we have people laid off because of COVID, we have a lot of people hit hard, our economy is suffering, you know, so they become victims, essentially. And if they're victims, guess what? I'm the DA, I speak for victims, that's what I do. So it's definitely something that I will pursue and that I will investigate, and I will not, you know, hesitate to file charges if a crime is committed, and it's essentially a fact, as Mr. Strunsky said.
I don't think we might get through all of them, but we have a so. But this next one is also from online as well. So it's kind of like related. How would you address unethical deputy district attorneys with a history of prosecutorial misconduct? And relatedly, would you give low-level DDAs authority to resolve low-level offenses, to create more autonomy and eliminate the waste of resources that regularly occurs?
So I'll take the second part first, which is autonomy. So in order to learn and to be able to determine what the value of a case is, what the right disposition is, you have to do that by trial by fire. You have to learn, and you have to learn early on in your career where the stakes are low. Misdemeanor cases, the stakes are not nearly as impactful on victims or the defendant than they would be if you wait till that person is training in felony court. And giving discretion early on allows them to evaluate cases later on when it really matters, when the stakes are sometimes a matter of life and death. And what happens so often is we have these people that sit upstairs, the supervisors, and then we have people that come into my chambers as a judge, and those are those are the line deputies that are actually handling the case and know the most about the case. And instead of that judgment, there's a judgment from upstairs. And we need to have autonomy in the courtroom. We need to make decisions in the courtroom, and we need those decisions made by the people that know the most about the case. And that means we need to train the deputy district attorneys early on so they know how to evaluate a case. And they know what the case is worth. They know what justice is. And that's something that takes time and is a trial and error process. So let's do that early on so we can give the attorneys discretion. For me, supervisors should be guardrails. They shouldn't be determining the specific dispositions in cases. They should merely be keeping the deputy district attorneys between a certain line of acceptable dispositions. And that's appropriate, but when the supervisors are determining the sentence in each and every case, that's where we lose the autonomy. And also that's where we lose the ability to respect these deputy district attorneys as attorneys and as professionals. If we're going to hire these people, if we're going to say these people are good enough to work in the Riverside County District Attorney's Office, then we have to respect their judgment and their professionalism, and we need to give them the tools they need to make good, fair, and just decisions. Oh, the other question. DA misconduct. You know, misconduct is absolutely unacceptable. I mean, first of all, it's going to be investigated by the state bar if there's rating violations or any other unethical conduct, and it will be something that under most circumstances is significant, and if there's any kind of pattern, that person will not be working for the Riverside County District Attorney's Office. If there's purposeful conduct, even once to hide evidence or do something to deprive somebody of their rights, that will be, even if done a single time, grounds for immediate termination.
Prosecutorial misconduct has been noted in 39% of the cases that have been overturned in California. It is a major, major problem. And one of the reasons for that problem, I believe, is this win at all costs mentality that exists in the Riverside County DA's office and has been there for some time. And so, you know, the incentive is you win the case and you get promoted. Then you get, you know, the awards and the kudos. And that can't be where the incentive lies. The incentive has to be get justice, whatever that looks like, and get it with truth or suffer the consequences. And I know that there have been misconduct allegations recently. There have been many in the past. There were lots of studies at Harvard. There was a study on this that reported many prosecutorial misconduct allegations, and some of which were found true in Riverside County. So it is a serious problem that we have to take seriously. The Wrongful Convictions Unit will be reviewing cases for prosecutorial misconduct. And also, I will be appointing an ethics officer who will run a committee. And the ethics officer will be responsible for training on ethics, obviously, and prosecutorial misconduct and what that is, because a lot of times I found in my experience where I saw prosecutorial misconduct happened a couple times in trials that I had where the trial ended because of it. And, you know, most of the time I think it's a lack of training, because most people get in this business for the right reasons, not to lie, cheat, and steal. They get in it because they want to do good, but the training isn't there. And so these things are actually happening. Now, the more egregious ones obviously are hiding things, Brady violations, and those result in wrongful convictions. So we have to take care of those, and I will deal with them extremely seriously. With respect to the discretion question, that has been something on my mind for the last 16 years of working in the criminal justice system here in Riverside County, because it's always like, well, let me go ask. Let me see if I can do that. And I'm talking 10-year lawyers, you know, or more. Extremely experienced attorneys in that office don't have the discretion to resolve their cases. And then they have to go to the top and it delays the case. And I might have a client sitting in jail, right? Waiting for this resolution. So this is a problem. We definitely need training in the office. We need to trust that they know what justice looks like, that they're honest and they're doing it for the right reasons. And we certainly don't need to penalize people for giving fair deals, which is essentially what happens right now. And I have to tell you, a lot of deputy district attorneys have left the office in the last few years. The morale is extremely low. And I believe that that is because of this lack of trust that their supervisors have in them. Or if they have an opinion about a case and it contrasts with their supervisor, then there's a big problem. You know, so we have to get to a point where we trust the experienced prosecutors with full discretion. And then we don't micromanage, we supervise and support. That's the difference. So you provide the support for the deputy DAs. You don't micromanage them and make them feel like they can't make any decisions on their own. They went to law school. They've been to trial probably at this point already. I mean, they're capable of doing this stuff. So we have to be able to give them that discretion.
And I do know we are running a little bit behind on time, but there is one more question from the audience. How will you ensure the safety of the undocumented community here in Riverside? Do you think the undocumented community should be criminalized?
Okay, I was hoping that we would talk about this because it's critical. And I want to talk a little bit about what the district attorney's role is in dealing often with the undocumented community. The point where a prosecutor deals with the undocumented community is in plea bargains. And there was a law passed, Penal Code Section 16.3, that mandates that prosecutors take into consideration collateral consequences when negotiating plea bargains. I can tell you that unfortunately, this is not something that is done on a regular basis. And I don't think there's any policy within the district attorney's office regarding this. There doesn't appear to be any indication of how many times they're taking immigration consequences into consideration. I can tell you that it was rare. in the criminal court that I worked in. And this is critical because if we see a stark contrast, a big gap between the criminal penalty and the collateral consequence, in other words, deportation, versus a criminal penalty that's much more lenient and much less devastating to that individual, we have to really ask, why aren't we making the minor changes? Often we're talking about merely changing a word in the charging document to get to the point where we can avoid deportation. We need to start doing this. And one of the things that I'm vowing to do is we have 240 lawyers that work for the DA's office. We're going to hire an immigration lawyer, expert in immigration law, that's going to advise those attorneys and going to train those attorneys on immigration issues. Because we need to be able to tell the attorneys what you need to do in order to avoid immigration consequences if it's known that that is an issue. And obviously that's something that needs to be brought up by the defense. But this is critical. We should not have a situation where the collateral consequence is so much greater than the criminal penalty. And if we do, we know something is really, really wrong. We need to recalibrate that, and we need to make sure that we keep track of these cases so that we know how many times the district attorney has actually complied with 1016.3. That's the law. That's the law, that the district attorney has to do that, has to take that into consideration. And that means really taking it into consideration, not just think about it for 2 seconds and reject it out of hand. That has to be a very significant factor in every plea negotiation in which the defense has indicated that there is a potential immigration collateral consequence.
When it comes to immigration consequences, I have a pretty comprehensive and innovative approach to how to deal with that. And I will have a unit that is dealing with reviewing cases for immigration consequences because it is quite impactful in our community. We have a large Latino community in Riverside County, and so we need to make sure that we're following the law. And it is the law. Penal Code Section 1016.3 requires it. Requires that the prosecution take into account any consequences for immigration for certain charges. And I can tell you, certain charges like drug charges will result in deportation. So what's the underlying problem? It might be rehabilitation instead of criminalization and punishment that would result in deportation. So again, rehabilitation is a huge priority. So we can combine the 1016.2 compliance with rehabilitation. And we can rehabilitate our immigrants and make sure that they are getting services they need for these crimes that do result in deportation, like drug crimes. Also, I will be employing a consultant. So similar, I will have a consultant who is an immigration expert, an attorney. I already have talked to him about this and he's on board. And essentially what we will do is that person will speak with my team about these cases in every instance. And the benefit of that is that not all defendants can afford an immigration consult, right? So we have a lot of immigrants who will have a public defender and they won't have an immigration expert to consult with because you have to pay extra to go to that person. So this is going to help them as well because it'll be an independent consultant coming in and reviewing cases to make sure that we have compliance with the law. And one more piece that I will add to that is that there is a penal code section that is not often discussed. It's called Penal Code Section 745. And what it is it prohibits prosecutions, convictions, and sentences that are based on race, ethnicity, or national origin. Not a lot of people know about this penal code section, but it is absolutely the law that it must be taken into account. And so I will have my wrongful convictions unit review cases that have been essentially racial profiling, is essentially what that means. And that could result in convictions being thrown out, and sometimes it results in just a reduction of charges by the judge in the case if that's found to be true. So this consultant will be looking at these cases for those purposes to determine what charges we can change the charges to so that they don't get and suffer the deportation consequences. But also I want to combine that with the promotion of rehabilitation because we not only just need to avoid the deportation consequences, we need to avoid future crimes. So we need to kind of, again, a holistic approach, looking at it holistically from start to finish. And this is absolutely in compliance with the law, and we are required to do this. So it is a public safety issue, and we need to be spending resources on it because the law requires it.
Okay, apologies. Okay, so we are over time, but we're going to close it up here. We do have all your questions, so what we will do is we will email these to both of the candidates, and we will, if it's okay with you both, if you can answer them via email, we can send them all to our participants, just so you have all the answers to your questions answered. We're going to close it up, so I'll hand it over to Vanya, and we'll close it up for tonight.
Thank you, and let's thank the candidates for coming out. Thank you both for asking the questions and just being here. We really appreciate it. And let's thank yourselves for being here. This is heavy duty. This is Thursday night. You know, could be doing a lot of stuff, but you're here. And also thank you to the friends who are watching via YouTube or social media. We are live streaming this event, and we appreciate you for looking, listening, and thinking. But before we close out, we wanted to offer the opportunity for you to share where people can find out about your campaign information. If you want to share your website information or contact information, please do.
Strunsky.com, STRUNSKY.com.
You guys are making it. You're making it easy on me. I had a whole closing statement. Come on.
That sounds like
15 minutes. You can find me at Lara4da.com or laragressley.com, LARAGRESSLEY.com. Just Google me, I'll pop up all over the place. Apparently when you run for office, you get a lot of Google hits. So you'll find me if you just Google my name. And I appreciate all of you being here and engaging in this process. It's a super important race. Extremely important. I can't even tell you how important it is. So I appreciate you all.
Gracias, Ernesto y Marina. Que tengan buena noche.